Thank you very much. Welcome, folks. So this is number 3 in what we call our ROI squared workshops. ROI squared is our way of doing a bit of shorthand for the fact that we believe there's 2 main kinds of ROI. There's obviously the return on investment, but also the risk of inaction. So, important to note that every action in business is an investment. So no matter what we do each day, we're investing in 2 possible things. One is our current earnings potential, our trading for today. So what we earn today, but more importantly, perhaps we're investing in our brand, which really affects what we can earn tomorrow and what ultimately our brand and business will be worth at some point if we choose to have an exit strategy. So in the first instance, it's about trade and what we're earning. In the second, it's about our brand and accruing long-term value. So before we actually start doing creative or start doing brand strategy, the first thing that's really important to do is look at your business goals. Many agencies will just jump right in and say, let's start creating some beautiful pictures. Let's make a really clever campaign. But if you don't first look at the ultimate business goals, you're probably going to be throwing a lot of money away that you could be investing more profitably. So we look at our business goals and then we start to establish business strategies. What strategies are we going to need to get to those goals? IP strategy is a core idea within this, and how we manage that is really important. Because once we've identified the business goals, which might include an exit strategy, might include an IPO, could include all kinds of things, that really affects the way our business strategies are then translated into verbal brand narrative. Verbal narrative is how we talk about who we are. It's our name, for example. It's our promise statements. It's the story that we tell on our About Us page and how we talk, the tone of voice that we use when communicating in words. That's then underpinned by our visual narrative, how we make those things look. What does the name look like as a logotype? How are we going to represent them in colors, the way we treat pictures and images? What does it look like when you walk into our environment? Ultimately, those then only help us to reach our business goals if we translate them into behavioral brand narrative. That's how we act. How we translate those into our procedures, our processes, the customer UX that we deliver every day. In each of those different quadrants, we actually have the opportunity to name things, to create intellectual property. That intellectual property quite often remains hidden in a lot of businesses. They have a name and a logotype. They might have a promise statement, but there's a lot of other hidden IP that they never capture and protect and never turn into the assets they could. So that's a lot of what we're going to be talking about here today. Taking your verbal and visual brand narratives, seeing where there's gold in that, translating them into behavioral narrative that authentically represents your promise to the market through the experiences they have, and protecting all of that by protecting your intellectual property.
So one of the things we find a lot when we talk to business owners and brand owners, and particularly entrepreneurs, is this response, which is, the guys, I understand IP is important, but I'll think about it once I've got things up and running. You know, I need to get to the market, I need to start earning money. At that point there, I'll start thinking about the IP. And I understand the practicalities of that, and we understand where that comes from. However, saying that is the same as thinking, I'll articulate what my value is once I'm already delivering it to the market. Now, if you're going to do that, you're wasting a whole lot of time and effort in the beginning, and you don't have clarity. And starting off from a position of no clarity means that everyone you talk to is going to be unclear exactly what value you bring to begin with. So that's going to give you no traction. When you start off in business as an entrepreneur, you need to look at your business, you need to figure out what your value is, and you need to articulate that value.
And then you need to take that value, make it visible, tangible, real, and protect it.
So you guys are already running businesses here, startups here, we've got scale-ups here. There's already a lot of value inside of your business. There's already a lot of intellectual property inside of that, describing that value, describing those benefits to that market, describing the uniqueness of those things. Making it visible, valuable, and protected is essentially what we're going to talk about today. And it's really something you should be doing as a task in your business. I don't know if you can hear, there's actually a bin truck driving past the office right now. Apologies for any background noise.
Behavioral narrative fail.
So welcome to our third and final series. This is where we're going to delve into some of the detail of alchemy, the alchemy of intellectual property. And what does alchemy mean? Well, alchemy is the mythical process of turning lead into gold. And if you know that lead is only a few steps away from gold in its properties. There always was the idea that maybe we could change one into the other. And what does that mean for business? Well, at the moment, you've got a lot of things in your business which are the lead, the structure, the industry of your business. It's making your business work. But actually those things are the gold. When you look at them closely and you articulate their value, those things there make the difference between longevity. There's a lot of stories here about using IP strategically, particularly for startups. I know that in lots of situations when people have valued and protected that IP as startups, they've come to the point where maybe there's an end of the journey and they've scaled down and sold out, but kept the IP and then sold the IP to competitors in the market as an exit strategy. Other strategies have been to continue to trade, but to focus more closely on one area and license the IP you've created to other people. You can only do that if you make the IP visible and valued and protected.
So quite often we talk to clients and they're every day just in there doing the do. They're doing what they do. They're trading, but they don't see themselves as different. And just about any company that's succeeding in the marketplace, particularly today, are doing some things different, but they just don't realize it because it's the way they've always done it. Intellectual property and protecting your name is something that we'll obviously talk about, but we also want to emphasize the fact that all of the protections, such as trademarks, patents, design, registered designs, all of those things can apply to things that aren't just a business name. They're things hidden within the business. So an example is one of our clients, JDL. Now, we didn't do their brand, but we were brought in to actually help them to figure out what made them different. What really set them apart was the fact that these guys were so meticulous in their quoting process. They basically were doing high-end housing redevelopments, renovations, specializing particularly in things like Queenslanders. But when they came in and did an assessment to give you a quote, by the time they were finished, they had a 25 to 40-page document that you could take to any builder that had everything specified and really removed all the risk when they did a project, whereas other builders had a very high level of additions and on costs. They didn't, because they did all the homework up front. So we made that visible through their informed quotation methodology. Informed construction was their promise statement, but we made this visible and gave them a way to talk to it. By giving it a name and giving it structure, when they did their sales process, it went from something that they did that was a cost center to them to becoming a profit center, because they could monetize that and charge for that process, which formerly they did for free. And then people would take away and use themselves, and they lost that money and potentially that client. So by valuing it, making it visible, and building brand narrative, sometimes you can monetize things within your business that you didn't know you could. One example.
So one of the things we should know about that is that we came up with Informed as a piece of intellectual property for them, because it really described that process. The fact that they came into your building, into your home, and you made informed decision, and of course the formation of the outcome.
And throughout the process, they also kept you informed on a day-to-day basis using a portal that they'd work with and developed, so you could see how your project was progressing. So you were constantly informed.
And Informed is now a trademark for JDL Constructions. So they've actually gone ahead and they've trademarked that, because any IP that we suggest, we like to do our homework and make sure it can be owned. Otherwise, you're investing something you can't own. It doesn't really make a lot of sense.
Another example is Facta. They came to us saying, we're developing a software program that's going to help managers. We're software developers. But what they were actually creating is a way to use software to create harmonious workplace environments. They were in the business of workplace well-being. but nowhere in their descriptions did they talk to that. So we created the idea of behavioral harmonics because they use behavioral analysis to understand people's different behavior types so that they can communicate more effectively together and raise productivity through wellness and better communication. They needed something else, and it needed to sound like a science. Like, I can get a certification in behavioral harmonics. I'm a behavioral harmonics coach, and we're creating behavioral harmonics ecosystems. A completely different way of looking at that aspect of their business. And they went from being software developers to being something much more specific and differentiated in the marketplace. And it changed the way they thought about themselves, which changed their behavioral narrative. Very important. They trademarked that as well. It's no longer a TM, it's now an R.
Mm-hmm. And so is factor.
So is factor.
And factor comes from the name factor. We came up with the factor because it's factor non verba, actions, not words. And it really was about, so if you're a manager and you had several people to manage in your team, but they were very different personality types.
And you've done the DISC training, but maybe it was just a tick in the box to say that you've done this behavioral training and then you never used it. That didn't work.
Yeah. So they actually had this, their software actually prompts you to say, well, I've got a meeting with Joe. His personality type is this. And therefore, when you talk to him today in your meeting, present the information this way.
Here's some coaching tips.
So when every time they had a meeting, they were finding a harmony between manager and staff that meant the communication was being heard. So it was actually making that theory active. So it's actions, not words, factor non verba.
Is it worth protecting your intellectual property? So for startups, particularly in scale-ups, the earlier you start to do this, the better, particularly if you're looking for investors. If they see that you've got your governance correct and that you've protected your governance, you've done the right thing, you've got your trademarking, you've done what you needed to do to capture your IP in a smart way, they're much more likely to invest in your business. Same with when you have an IPO. If you've done your governance correctly, you're more likely to have a successful IPO. If you haven't, you'll struggle. Is it worth protecting? Well, at the end of the day, those who do it right and protect themselves, but also invest in the right things, can earn or create very great assets.
So we've got a question here on chat from Jonathan. You say, it may be exactly on topic. Is it best to form a holding company for the IP earlier rather than later for a startup? So we're going to cover that off a little bit later in this presentation, Jonathan, but in essence, yes, maybe not a holding company, maybe a holding entity. So that might be best suited to be something like a family trust, for example.
We'll talk to that, but you're spot on.
Yeah.
Perfectly on the game.
So if we look at that symbol on its own is worth $26 billion. Not a word. I mean, how do you describe that symbol? The fact that you know in your head what to call that symbol is testament to that branding spend. But is it worth protecting your IP? Well, 26 billion for that, 37 billion.
And this valuation was from 2014, so it's risen considerably. The interesting thing about Intel Inside is that's a campaign. It's not the brand. The brand is Intel, but that campaign revolutionized their valuation. From the time they did this in the 90s forward, their brand valuation growth was logarithmic. It was amazing. But they protected not just the brand, but the things within the brand that were important, in this case, a campaign.
So in this case, when we're looking at this campaign, what it's actually functioning as is a credential. So they're lending this out to the market where then other people are making machines that contain Intel processors. Intel then are saying Intel Inside. So people are using that as a credential to sell their product. So that IP is worth a huge amount because other people are leveraging it to create sales.
And then they did something very interesting with that IP. First, the exclusivity agreements that they had for people to use it on their machines was dead tight, it was watertight. Secondly, they actually arranged to tie themselves to the Apple brand when Apple formerly hadn't used anybody else's processors. Again, each of these steps is something that you can do once you've actually identified and valued the brands and the IP within your business.
So let's just have a rundown now. When we talk about IP, when we talk about protecting, what kind of protections are there out in the market? So what can you do? All right, let's have a look at it. There are essentially 6. Now you'll wave your hand and say, I can see 7. But TM and R are the same thing. They're a trademark. So we've got patents, we've got trademarks, we've got registered designs, we have copyright, we have plant breeders' rights, and we have circuit layout rights. Now, in our talk today, there's going to be limited value to us going through plant breeder rights or circuit layout rights. So we're not going to cover off on those 2 right now. But we'll give you an overview.
If there are any plant breeders in the audience and you'd like to talk to us about that later, we're more than happy to have a chat.
Yeah, sure. It's one of the rarer areas. So let's just talk quickly to patents. Patents do offer a lot of protection. They're timely. They take a lot of time consuming to actually get hold of. And that makes things problematic. They're also very costly to get hold of.
So as an example, an innovation patent, which means you're actually just altering or adding an innovation to an existing patent, might only take a couple of weeks, but most general patents take 4 to 5 years. It's quite a long investment in time.
So the intrinsic complication here is that you have to satisfy criterion to achieve a patent. And the first criterion is that it needs to be new. So if you've got it in the market or it's published in any way and people are aware of it, it's fundamentally not new. Which means that if you're going for a patent and it takes 4 to 5 years, that's a 4 to 5 year lead time that you have to sit on your patent, on your idea, which makes it very problematic. The second thing is it needs to be inventive. What does that mean? Well, that means that if we went to the market, your particular industry, and we got some clever people from your industry, and we showed them your idea, that they would say, oh yeah, I wouldn't have thought of that. That's pretty clever. But if it's obvious to them, it's not inventive. And then the third thing is quite obvious. Is it a useful invention? And that's probably the easier of the 3 criteria to demonstrate that it's got a use, that can perform a function. When you get a patent, it will protect you for up to 20 years. At which point, it's done. You can't renew it. That's your protection. So at that point, it becomes public common usage. So look at examples like, well, actually, let's not look at examples. Let's go on to registered designs. That's kind of interesting as well. So registered designs. Registered designs is similar to patents, except what it protects is the way something looks. So that becomes quite specific in where it can be used. You might use it, for example, if you were designing product design, homewares, electronics, the way they look, for example. I'm sure that Bang & Olufsen had a lot of registered designs, because the way they looked was quite unique. How long does it last? Up to 10 years.
You should note that your first registration will last 5. You have to renew it at the end of that. If you don't, it lapses. So if you want the full 10 years, you actually have to monitor that and be on top of it.
Yeah. And that's the case with all of intellectual property protection. It is down to the person who is registering that protection to follow it and enforce it. Now, there are ways you can manage that. You can have a lawyer or an attorney on your behalf watch, or you can stay on top of it yourself. If someone makes a transgression against a protection that you have, it is up to you to enforce that.
And it should be noted that quite a lot of law firms these days have created automated tools which allow them to safeguard your trademarks or your IP protections in the case that somebody else might be trying to do something which you would challenge if you saw it, but if you don't see it, you don't challenge, and you might miss the opportunity.
Okay, let's go into trademarks and copyright. So why have we got trademark and registered symbol here? Why have we got those as 2 different things? And the reason we've got them there as 2 different things to talk to today is because it's confusing. So if we go to the IP Australia site and we start to look at these things, you'll see these are the descriptions they use. So what we're talking about here with TM and R is the same thing. We're talking about a trademark. And incidentally, trademark in Australia is 1 word. whereas around the world you'll find it's 2 words.
Or reverse. Australia trademark, US trademark, 1 word.
Okay. I thought it was that way, man. You sure? Okay. So we've got letter, number, unique symbol, word, then word, fancy, figurative. They talk about it in different ways, even on their own site and within their own literature, which makes it very difficult to understand what you're looking at.
So when you're applying for a trademark, the best way to determine which type of trademark you're going to apply for these days is actually to go to the trademark application process, not to their instructions, because some things you will not find when you go to apply. So go to figure out what you're going to apply for from the application form first, and then do your research and complete the application.
Copyright. So what does copyright cover? Well, copyright's a bit different. So copyright's it's different in the sense that there is no application process for copyright. Copyright is something which is automatically applied as soon as something is created. And it has to be something that's created. So usually covering works of art, literature, plays, movies, videos, images. So it's things that are on the creative spectrum, but it could easily be the copy that you've written into your website, for example. Now, that's a creative act. So once you've written that, it's covered. You don't have to do anything to cover it. We would recommend you do some things to show that it's covered, to make that visible, but you don't have to do anything. It's intrinsically covered, as long as it's original.
So we'll cover off on some tips and tricks about that.
So some bits of advice for you here with trademark is use a TM. So one of our core bits of advice for everyone out there who's running a business is when you're talking about something and you're discussing something as a thing, even if that's within your business, we're talking about intellectual property as a thing, name it, put a TM against it. If it's your process, name it, put a TM against it. If it's a product, a sub-product, if it's a system, if it's a credential, name it and put a TM next to it. And what a TM does is it says, I intend at some point in the future to register this as a trademark.
And in the meantime, I intend to use it as the mark of my trade in practice.
You don't have to have any trademark to do that. And there's no time limit on doing that. You can do that forever.
So there's an interesting thing that happens sometimes depending on the size of a company. Those with the biggest lawyers sometimes stop spending money on registrations because they put TM on everything they own. And if anybody infringes it, they go back and they attack you through prior use. The majority of us can't do that. We should still TM everything because it's a deterrent, but always think about getting it registered.
However, the register symbol is a bit of a holy grail. Don't use that unless you actually have a registered trademark, and you can only use it while the trademark is active and in use. If you make a mistake there and you use it when you don't have that protection, then there are penalties, legal penalties for doing so, and they can be significant. The copyright is automatically applied, which we've discussed, and it lasts for the creative's lifetime plus 70 years. So I think the copyright for a few things is starting to come up now, Sherlock Holmes being an example.
So when we talk about trademarks, that's the core or the largest element of protection that we're going to talk about today. Patents, they're hard to get. They can be useful, but hard for most of us to deal with them. Copyright, you get it automatically. There's some tips we can give you to assist, but in protecting your core brand family, a registered trademark is the best and the most important. There are a lot of different kinds of trademarks though. We can trademark our brand name, but there's also associated brands, partner brands. We brand products within our brands. If you're a car manufacturer, you can brand and register the model as a brand. Credentialing and credential, these are two different ways of looking at the same thing, but we can build or bring credential brands into our business. So something like FSC, which is a Forest Service certified paper, or a green credential, the B Corp credential for those of you who have social enterprises. All of those are important credentials we bring in, but we can also cross-credential within our business. So Intel Inside is one of their credentialing brands, but we can cross-credential things which show parent company and product, or parent company and innovation and process. 3M is an amazing example of a company that has a master brand, but their brand is about creating the innovations, and then they trademark yellow for their Post-it notes as a color, as well as Post-it notes. So each of those separate things adds an element and an asset to your balance sheet, depending on how you build that family of brands. Getting it right and ensuring that you've captured all of that IP, named it to make it real and tangible, and then got a registration to protect it, is vital, particularly in startups.
So if you think about 3M and Post-it, that's kind of an interesting example, because they have a registered word mark for Post-it. They have a registered device trademark, which is the logo, the visual way the logo looks. And then they've registered the color yellow of the pads. So you can't infringe any of those trademark registrations. So you can't produce Post-its that are similar color. You can't call it Post anything. You can't call it anything because it would get too close. And you can't design a logo that says something completely different but resembles the logo of Post-it. So in doing so, what they've done is really tied up that market and made sure that they're fully protected with trademarks. One good example of looking down into the value within your business that maybe won't be your name or won't be your product, but can be trademarked, is Shimano.
So as a mad fisherman, I look at this and I can tell by looking at this that the reel that includes all of these sub-brands is a very high-spec reel, because they've actually trademarked and named each of the innovations that create the differences that underpin that reel. If you look for X Protect, or if you look for Hagain X, you will see those things as individual trademarks in Australia and around the world, because they've protected those. Nobody else can use them. Daiwa will be out there creating its own versions of these, or trying to, but simply by trademarking and protecting that innovation, even if they didn't have a patent, it creates a deterrent, and other people will be less likely to try and compete directly with them because they've protected that element. And not many people really understand how far those protections stretch. So remember, these are just small things, innovations in the way they've designed the spool. They didn't trademark it, or sorry, didn't just patent that. They actually trademarked it, created a name for it that they could promote on its own. At some point, they could sell or license that technology, that innovation, and that brand to one of their competitors, should they choose to do that as a mini exit strategy for one portion of their business, because they build the value into the sub-brand. So it's always important to remember, within your business, there may be sub-brands that you can divest and have an individual exit strategy for that element within your business, while still maintaining the main trading business, or perhaps intellectual property growing business.
So one of the things to look at here on screen is what we've got here are trademarks, which are logos, device trademarks. Now, what makes me able to say that is, if I look at any of these individual marks, I can tell you that they're describable. So what does that mean? That means that if I look at, let's take the first one, it's KN, is it KN?
It's actually HAN.
HAN.
Or Hagain.
Okay.
But it's kind of got a G tricked in there. So you can describe that it's got all the letters of Hagain, but they're melded into that one really terrible logo.
Yeah. So you can describe it. You can describe it as type with a house on its side. You could describe it as a split up version of the three letters, or a hidden G in the middle. I can describe that in words in my application, which means that no one can do something which is a similar idea of approach within a logo application as a trademark. So the describability of a logo is quite key to getting a logo trademark. If I just typed out the letters and there was nothing unique or describable about it, I would struggle to get that trademark.
We had a comment from Duncan about thanks to Mickey Mouse. I assume that's about being able to trademark elements within your brand. There's some really interesting things around the Mickey Mouse brand. Not only did they trademark him, but they trademarked the ears as part of the design. And in recent times, Deadmau5, the musician who always wore the headgear that looked a little bit like Mickey Mouse, he was taken to court by Disney and said that he was too close to Mickey Mouse and he needed to pay them royalties.
They settled out of court.
They settled out of court. So I'm not sure how that ended up. But
we never get to find the actual figures. Yeah. But we've talked to a few lawyers who've made our eyes water with the stuff they can tell us off the books.
Yeah. Pays to protect.
Okay. So one of the things to look at here is in your own brand family is what the model is. So do you have a brand that sits above everything? And then everything within your company and your offering, it falls under that brand as an offering. So something which is a good example of that is Yamaha.
Doesn't matter if it's a violin or a motorcycle, it's got the same logo, the same name. It's a branded house.
Yeah. Whereas if you looked at P&G, which is Procter & Gamble, everything within their stable is its own brand, its own identity, has its own style guideline, talks to its own market. That's a house of brands. So understanding your business and which of these two models you fit into is going to be very key to get right early on.
And each then has or creates different sub-brands, such as credentialing brands. You become a Procter & Gamble company. You become a 3M innovation, which links you back to the brand, building equity in each of the brands. But you have to figure this out and establish it as one of your business strategies before you can start to make sure that you build the correct structures and sub-brands.
So this is a top IP strategies, hints and tips we're going to give you here. So some of the things we would be telling you to do if we were meeting with you in person, but with COVID we're not. So one of the things we would say to each business owner we've met, some of the top tips we would give you. Number one, TM everything. Just go at it, have at it, go for it. There's no penalty for doing so. It acts as a deterrent and it shows you're switched on to IP.
But just be careful that you're not putting TM next to something that somebody already owns.
Yeah. Name and secure your IP assets. It goes without saying, if you create a name, as Paul just said, make sure that name is actually trademarkable, and then secure it. Make an application. Your application protects you from the moment that you've made the application, assuming you're successful. So you don't get protected from the point of getting it, you get protected back to the point where you applied. You have your line in the sand there. So applying early and as soon as you've got it sorted is definitely a recommendation.
And as a sub-clause to that, the second you start using something, you start building some equity, just not as much as by trademarking and getting it registered. The second you put TM next to it and can record that as a point in time, you start building equity, again, at a slower rate than getting a registered trademark, but it establishes prior use, and that's really important.
This is what Jonathan was talking about before, separate IP assets away from trading entities. So we'll go into that in a little bit more detail in a second. We'll describe what the strategy and structure for that should be and how to establish revenue streams for that. And the fifth thing is a little bit contentious, but it makes sense from a business point of view to make sure that the business itself or the trading entity in that case is assigned the rights for that IP. People come into your business and they create ideas with you, together with you, for you. Make sure that the rights for that IP don't sit with that person, but they sit within the company and the task at hand. So that will need to be part of your contracting agreements.
So what does that look like?
Okay, so let's talk about holding entities for intellectual property. So whatever entity you have, in this case, we've got the example of a family trust, but it could be another holding entity. That's where the ownership of the intellectual property should sit. But that's not your trading entity. Your trading entity sits outside of that. And what happens is, because the IP is not owned by the trading entity needs to license the intellectual property. And when it licenses the intellectual property from the trading entity, It recognises that by paying for it. They're paying a license fee, and we get a revenue stream going back. Now that revenue stream now shows on paper money being attributed, revenue being attributed to the value of that trademark, that brand.
So that revenue stream also can take various different looks or values. It can be a license, so you might pay an annual licensing fee, and then royalties on top, which is kind of the usual structure where you might pay a percentage of revenue. The more you can structure that so that it shows that revenue stream, the more valuable your IP becomes. And when it comes time down the track that you might want to expand your business or change your business strategy, perhaps partner with somebody, the work that's been done in that trading entity, generating traffic, generating royalties and licensing back to the IP holding entity, starts to show that just the IP alone is worth something. When you can do that, you can then license other people. So at this point, it might only be you trading, but down the track, you might say, I'm going to franchise, or there's somebody in Melbourne who says, you guys have got this nailed. I want to take on your IP and your systems, your brand, and enter my market using those tools. You can license it to them, and at that stage, your IP grows exponentially as you're continuing to show a revenue stream purely based on the power of the intellectual property.
So this may marry up with interesting growth strategies as well. Yesterday, I spoke to a real estate client, and she said to me that she didn't want to have more than one office because it meant she had to have another license. And that would be costly and prohibitive, so she didn't want to be doing that. And we talked through this IP structure, and we said, well, okay, how about if you create that one office, you've got that one license, and then at some point in the future, you meet somebody who wants to buy into your brand value, open their own with their own license. What you can do is this model here. You can license that brand to that person with conditions. That person then operates and pays a license fee and royalties back into the holding entity.
So as we're creating those things as assets, your intellectual property as assets on your balance sheet, when it comes time to have an exit strategy, it provides you a much wider range of options. One option is I sell the trading entity and the brand, but because I valued it separately, I can attribute a value. We don't just say, oh, you have to pay me for goodwill. No, we can show that there's a passive income stream for this intellectual property of X. You need to pay me a business multiplier based on that if you want both. But if you can't afford that, I'll sell you my trading entity, including my customer base, and you can continue to trade with those assets, but I'll continue to license you to do that, and I'll continue to take royalties, which means that now I'm no longer even trading, I'm simply getting a passive income from the value based solely on the IP. Just a couple of examples of how you can leverage that to be more effective at an exit strategy point.
So this is, you would have seen a handout being circulated in the chat window there from Rachel. And this is just going through that. This is our cheat sheet. So what should you have on hand to refer back to as you're operating your business? There are a couple of things here that you can do we're going to give you some do's and don'ts, some simple guidelines, and we'll just talk through what they are. So let's talk about copyright to begin with. So do's. So do be original. So you're only actually going to be copyright protected if you're creating something original. You're not going to be copyright protected if you've based that off some other work. It does need to be original. When you do create something, anything, even your website copy, make sure, and you'll see down the bottom left screen there, copyright Untold 2020. Make sure that you put down there that it is protected. Make it visible. And save previous versions.
This is particularly important in the new digital world that we live in. The amount of clients that we've seen that have published copy or images or other copyright assets, and then they update their website, and all of that disappeared because they didn't save a copy of their first website. Some companies are on their 10th website. If you create that copyright material, it's important to take those files, save them on the date that you first published them. That's also good if you've got an IP lawyer, send them through a copy. So you've got a record of it at that date that it was originally published, and you can actually prove it.
Now the next one is the don'ts, and this is something that I pull my hair out with quite regularly. So I'm going to cover off. So don't adapt original works, which is pretty straightforward. Your competitors are going to be saying a lot of the same things you are. It's very tempting to go and take a copy of what they're saying and adapt it to your use. Don't do that. Start from scratch. Write your own story. Be clear about what your own value is. It has much more value to you at the end, and you're not infringing anyone's copyright. If someone sends you copyright, sends you a copy to use, or sends you an image to use, check that they have the copyright for that. Check that they created it. Check that you can use it. Write them an email, say, okay, am I okay to use this from a copyright standpoint? And get an okay back from them. But for goodness sake, check. Now, in the business world, number 3 is prevalent. People make...
Sorry, just one note on that. With the intelligence of AI that we've got out in the world today, the big players are getting better and better and better at detecting copyright infringement. So it used to be that people would get away with it because it never turned up. But when you can search on individual colors of certain images at certain sizes, as we can with the current algorithms, it's becoming more and more dangerous to infringe in this space.
Mm-hmm. Now, images. In the business world, people are creating PowerPoints, they're having discussions, they're using images that they found, begged, borrowed and stolen. They might have used them for 20 years and they're still using them. And the assumption is that it's okay. It's not okay. So images particularly carry very good protection and copyright, and you need to make sure you have the rights to use the images. If you don't know, don't use it. The penalties for using it means that people come to you and they say, you've already done it, and now it's up to me what you're going to pay. And we've had instances with clients using images from photographers that they found online. That photographer very definitely owns that copyright. And that photographer says, well, if I had to take that shot for you, it would have cost you 10 grand. And you've been using it for this amount of time, and I would have charged you royalties per year. And then you've made an infringement. So we're going to add all of that up. And that's what you're going to pay me. And you have no leg to stand on.
And again, centralization of intellectual property assets like photography is happening. So the people that actually own those now are more and more likely to have the money and wherewithal to take you to court and win, unless you've got big money bags yourself.
So a question here from Duncan Mansfield, which is, do you have a take on embedded links as well at this point?
That's one that's actually been bouncing back and forth with one of our coder friends, because it's a hot topic. To be honest, to me, it's a bit too far down the tech path for me to understand it well enough to give you any advice on it. But we do have a couple of professionals who are, as I say, investigating or have been investigating that for some time, and working very hard to make sure they're across it. So if you want some advice, we can put you in touch with a couple of people who are very good at that.
But the top level advice here is, if you're using something which you haven't got the copyright for, get the permission to use it. So largely, it's a much better solution to actually ask for permission in the beginning than seek forgiveness afterwards when it comes to copyright. Maybe not the same with a lot of business decisions, but with that one it is. Trademarking. So trademarking cheat notes, do's. So if you're going to go and get a trademark, you're trying to think about naming something or applying for a trademark, what should you do? So don't be obvious. If you think about something which is obvious, if you think about something which is self-explanatory, which just makes sense, which is a no-brainer, chances are it's gone, right? It's gone, long gone, and probably protected. So if you're going to think about anything, you need to think laterally. You need to think outside of the box. When you've got an idea, Google it. Google. Keep going. Keep digging down. Make sure no one, nowhere is using that idea or something very similar to it, even phonetically similar to it.
Important to note when doing Google searches such as this, go to Google Incognito tab so that it doesn't use your predispositions that Google's been recording as much, and gives you a wider range of search options, because sometimes it'll discount things that it thinks aren't of interest to you, which is actually what you're trying to find.
So number 3, one of the hacks that we use is we go to ASIC and we look through the business name registers. So if you've got an idea and you come up with a name, one of the things we'll do is we'll go and look for that name and look for things that are similar or just one letter off dispelling that name. The reason we do that is that people over time will register that as a business idea, and that's the only way we'll find it. And it's only then by digging into that owner, finding their websites, looking at their published articles, that we'll start to discover whether they ever did anything with it. Because if they started trading with it or using it in relation to trade, then they will have some protection over it. The TM symbol we've covered, use it. And if you're going to make an application, there's an application process within IP Australia, which is called the Head Start. The Head Start essentially gives you a decision quite quickly about whether that's a viable trademark application.
It's not a guarantee, but it gives you an indication early. The second thing it does is that application process allows you to choose your trademark classifications, the industry or product and service classifications from a pick list. And the examiners prefer that because when you create your own class descriptions, it takes them a lot more time to check and cross-check them. But if you're working off their pick list, they're more likely to pass it through more quickly. So making their life easy is good. It costs a little bit more. You have to do an initial application and then a second payment. Don't forget the same second payment or it won't go through. But it's worth it because you do get that opportunity. If something does come up that might be a problem, you can address it early, and that might be as simple as dropping one of your class descriptions that might compete off of your application, and then it'll go through. So take advantage of Head Start, it's worth it.
The only caveat to that would be that if you were going for a trademark and it was a very difficult arena to get a trademark in, and the only strategy you had to secure a trademark was to be incredibly specific in your class description, well, then you wouldn't use a Head Start for that. You'd be using a normal process, and you would have an attorney or lawyer help you to make sure that that description, that class description, was very specific. Don't. Phonetic misspellings. So that's when you just naturally misspell a word, like flicker, for example, the photo showing misspellation. When you do that, they're not going to like it. And they're just going to roll their eyes and say, no way, and you're up for another fee. So don't do that. Descriptiveness, the core element of trademarking, is the question they ask. Number 1 is, are you legally entitled to own an asset? And number 2, is this descriptive? So would anyone in your industry find this a descriptive term to describe the goods or the services that surround in that industry? If the answer is even slightly yes, then it's a no.
So a good test for that is if somebody's likely to type the word or phrase into Google as a search term, then it's probably not going to get through.
Obviousness, again, if it's a no-brainer, don't do it. Similarity to existing marks, you need to do your homework. There's no quick way to do that. You're going to have to go through and you're going to have to look at your competitors. You're going to have to search from an image point of view, from a description point of view within IP Australia. So
if you create a logo type and you're worried about whether it might have a search, it's harder to find them using IP Australia, but putting that logo type into an image search on Google can give you some idea if somebody is using something very similar, or if somebody tries to sell you a logo, you can put it into the image search and see if they bought it off Fiverr and are trying to sell you to you as a markup, because there'll be hundreds of them out there.
Oh, clip art nightmares. So you just grab the icon from your new logo, copy and paste that, maybe make it black and white, chuck it into a Google search, and just see what you come up with. And if you find that somebody's basically using clip art within your logo, it's time to go and talk to a logo designer.
And finally, generic class descriptions. So when you do go into the application process, it's great to say all elements are all products within this class, less likely to get through it. So the more you hone it down to say it's automobile tires as opposed to automobile parts, for example, the better chance you have of getting a trademark application through. You have less protection, but you're not risking your investment if you're only going to trade in that specific area anyway.
Okay. So there's a bit of repetition in our talk, so I'm sorry about that, but we sometimes want to go into a bit more detail on things. But that should give you a very good standing point to make decisions or to ask the right questions at least.
And to start creating the structures that will protect your intellectual property.